quite know, I've put a couple of things into the police lately. I've got a letter from them the other day for the Legal Services Department regarding my claim for payment in connection with property that state is outstanding. But I've also put a claim in for my property which was held for. This is my solicitor, which I've let's see what he's got to say. Hello.
Hi, Toby.
Hello, Sam. All right.
Yeah, I'm fine.
Good. Good.
Missed call from you.
Yeah, sorry, mate. It's I'm just wanted to give you a call, just to sort of sound you out really a little bit.
Okay.
I'm going to. Have you heard of a guy called Carl Grant? Carl Grant. Yeah. He runs a campaign for truth and justice.
Okay.
Have you heard of him?
No.
He's a guy's from up in London.
Okay.
And I've been sort of liaising with him lately, and and I think I'm gonna sort of gonna represent myself, Sam.
Okay.
I don't know. I just wanted to sort of sound you out to see what the procedure would be. Obviously, I understand you've got to attend on the 8th, obviously, because that's when the mention hearing is. But how would it sort of pan out from here and now? I know they've got dates set for trial, etc., etc. But obviously that's.
You will speak to the judge, and you will say that you wish to represent yourself, and I guess it will be down to the judge to make the decision as to how it proceeds from there.
Okay. Yeah. No. I just didn't know whether you'd sort of been in this situation before, and sort of obviously because there's dates that are set, isn't there? So.
Sorry, say that again?
No, it's just because there's dates that are set already for trial date and stuff.
Yeah.
But obviously, if I'm going to represent myself, then obviously I'm going to need some time. I'll take it because obviously you're going to have a lot of documentation, which I presume would have to be passed over to me. There'll be a lot of documentation that the prosecutor.
There will, but I doubt that given the time period as well, it's unlikely that the judge will allow further time. And also, there's no certainty that the judge will allow it anyway, because he will probably feel, given what's passed, that it will make a mockery of the court.
Well, again, yeah, I mean, but at the end of the day, it's my choice. At the end of the day, isn't it? If I want to represent myself, then I don't have to take.
It is. Well, you say that, but to a certain extent, the reason being, you didn't have legal aid. You have solicitors and a barrister who are completely competent. The judge will be of the view that there is no reason for you to represent yourself.
But that's my choice, though, isn't it?
Well, it's not your choice as such, because it has to go before the judge to make that decision. So you keep saying it's your choice. You can say, but he has to be satisfied that it's in the interest of justice. I've no reason why he will believe that it's in the interest of justice. It wouldn't be in the interest of justice if you choose to represent yourself and you are found guilty. Then it will be further reasons to appeal. There'll be more reasons to appeal. So there's no reason that the judge has to say yes, you can represent yourself.
Okay.
It's very limited occasions that criminal trial. There was a civil happens all the time, and family and all those types of things.
Yeah.
Because there's no risk of an individual losing liberty. I don't think there's any chance of you losing your liberty in this matter, but it's a criminal case, and so that's why in criminal cases it's not something that is taken is really considered. You understand? Because of the nature of it. It's not like you're arguing over somebody owing you £3,000, or you're arguing for a contact order or something like that. This is a criminal offence in which the outcome can adversely affect you.
Well, it's an allegation of a criminal offence, isn't it?
Yeah, but exactly. It's a criminal offence in so much as that's what this matter is. It's a criminal offence. It's not a civil matter. It's not a civil offence. It's a criminal offence. And so, what judge is going to allow you to represent yourself in what is a criminal offence?
The problem I've got is Sam, is that your relationship with the Crown system through the bar is different from the relationship with myself. I mean, I requested and required for you to act on my behalf, but if that doesn't fit in with the court system, but you're
but you'll be asked a simple question like this: have you been before the court before? Prior to this, forget about this matter. Have you been before the court before?
Right.
Yeah, and you were represented, weren't you?
Right.
So what is your argument on this occasion? If you're saying that you haven't any faith in us, I'm just a little
No.
We have represented you
No,
before.
Sam, please, sorry.
I'm just a little confused.
I'm just a little confused. Yeah, no. It's Sam. I'm not doubting your competence or your capabilities.
Yeah, but that's what I'm saying. The court will ask you that question. The judge will ask you a simple question. If you hadn't been before the court before, there's a number of things that you need to. The judge will ask you. If you're saying now, for instance, that that you believe there's some kind of coalescence between us and the court. Well, there really isn't. But that's if you mention that, judge will obviously say, have you been through the court before? And have you been represented before?
The judge can ask, to no disrespect, the judge can ask me anything he likes in respect to that, because as far as I'm concerned, that's irrelevant. I wish to represent myself, and that is it. I'm not going to get into any legalese debate and an argument with him. It's my.
But that's what I'm trying to tell you. Okay, I'm telling you that there is no reason that the judge is going to allow you to represent yourself. That you have a firm that you have legal aid which is granted. I mean, if you're going to, which you have done, basically refuse to give us instructions, the judge will have to make a decision as to how he wishes to proceed with that. But simply just saying that you don't, you want to represent yourself. That's a matter for the judge to decide on that. It's not something that's as straightforward as I'm going to represent myself.
I haven't refused to give you instructions at all. In fact, I come up to the office and we sat down some months ago. I haven't refused to give you instructions.
No. The only issue at the moment is with the psychologist, because that's a direction from the judge.
Oh, I thought that was something from yourself. I thought that was something that was you.
No. We had initially mentioned it and said we were going to do it, and then there was a direction from the judge when there was a mention hearing, which I told you about. Yeah. And the directions from the judge were that a report was supposed to be with the court for the 7th, which obviously hasn't been done. And
if it wasn't,
he wanted. Say again?
Yeah, and the letter also said. Just hold on a second. I'll grab the letter. It said, I discussed the implication of being held in contempt of court of our lengthy telephone conversation on Thursday the 13th of March. His Honour Judge Statman has directed that a psychologist report on fitness to stand trial, obviously whether I'm fit to stand trial or not, be served on the court and the prosecution by the 7th of April. A response is due to be received by the 6th of May. A mention hearing is listed for the 8th of May. In the absence of the above directions being progressed administratively, His Honour Judge Statman has relisted your trial dates for handling stolen goods 19th of May and the possession of prohibited weapon on the 9th of June. So that's all he's saying is basically if I haven't sort of gone to go and get a psychologist report to state whether I'm fit to stand trial or not, but from when our last conversation, Sam, you told me that this psychologist report was nothing to do with the court. It was to do with my ADHD, and to state that and if
that was before there was the mention hearing. We've had a number of conversations.
But the last. Sorry, Sam. Sorry to interrupt. The last time we spoke was that you said to me categorically. You said that. Look, Toby, if you go for this psychologist report, and the psychologist report comes back and proves that my ADHD would cause me to act impulsively and obviously flippantly to try to conceal one of the items, then you said if the psychologist report comes back and it verifies that, then that's fine, we'll use it. But if the psychologist report doesn't come back and assist in any way, you said to me that then you wouldn't use it. But now what you're telling me is the fact that the judge has ordered the psychologist report.
The judge has asked in relation to fitness to stand trial. filed is different. We needed one in relation to your ADHD. The judge has directed one in relation to fitness trial.
Right.
I had initially requested, when we had previous conversations, and I said that the reason that I wanted you to see a psychiatrist or a psychologist was so we could assess the ADHD to assist us with the defence of you impulsively pressing the laptop under the floorboards. That's what we discussed. Then there was the mention hearing, and the judge directed for the psychologist report because of the issues that had become apparent to the court, and that's why he wanted an assessment for your fitness to stand trial.
Right. Okay. So I just want to clarify.
That's the reason why the psychologist has contacted you as well, and we had the conversation. You said that you weren't happy to see him.
I haven't spoke to anyone. I haven't spoke to.
I know you haven't spoken to him. He said he's called you a few times and left messages.
Right. But okay, so I mean, as it stands, then, so I've still got. I have to attend on May. So how are we going to get this? Do I need to put something into the court to notify them that I'm going to be representing myself, or?
No, you didn't appear when in the next hearing, and we'll take it from there.
Right. Okay. Okay.
But I'm just a little perplexed because even if you represent yourself, you still have I understand there's no getting through to you. I understand that now, so I'll leave it as. But I'm just a little perplexed as to how you representing yourself, how that's going to change or alter anything. It really isn't, because you still have the same issue. You still have the same issue in relation to the floorboard, which is something that we're attempting to address with the psychologist. If the psychologist says that yes.
Sam, the issue which we've got, and the reason why I want to represent myself, is because you've got a certain protocol with the Crown. You've got a certain duties and liabilities to the responsibilities.
Sure what do you mean we have duties and liabilities?
Well, to the Crown. To the Crown. I mean, I've proposed a few different situations to you to put forward, but that doesn't fit in with the. I mean, I'm looking at more the common law, the natural law, but that doesn't fit in with what you represent, and you can't stand up there and use.
But even if you do, right? Just because you're not represented, it is not going to be taken on board.
That's.
You can say what you like, but something. I'm trying to explain to you that you are relying on this kind of stuff that you keep going on about, but I'm trying to tell you how things are in relation to the court. So it doesn't matter if you are a solicitor, a barrister, whatever. It doesn't matter. The facts are the facts. And so the court, the judge, will only listen to those elements that are pertaining to the trial itself. You can whistle off whatever you like. The judge will not take on board any of that. You representing yourself is not going to make any difference. You can talk about, well, yes, but you abide by this and you abide by that. Ultimately, he could end up holding you in contempt just simply because you're whittling off stuff that have of no relevance. Right.
Can you answer me this? Can a law breaker be a law enforcer?
Can a law breaker be a law enforcer? What do you mean by that, Toby? Can somebody who's broken the law enforce the law? Well, there's plenty of police officers who have convictions, maybe driving convictions, and so, there's plenty of solicitors, there's plenty of judges that have driving convictions, or maybe...
What about the Crown?
I'm not sure what you mean by that.
Well, what about the Crown? I mean, that's who's...
What do you mean, what about the Crown?
Well, they're enforcing the law. Can a law breaker be a law enforcer?
Well, I've just given you an example of how they can, so yes.
So the Crown, if they... So
what relevance has that got? What relevance has that to do with this matter at the moment? You can get sidetracked as much as you want. You're asking me, can a law breaker be a law enforcer? So, for instance, I'll give you an example. Can a judge be found guilty of, speeding or reckless driving and still be judged? Well, yes, it depends on how serious the actual offence was. So that judge could potentially have a conviction for, a minor offence.
What about the Crown?
The Crown will just be the prosecutor. sure what you mean. What
Well,
can
the
a
Crown,
prosecutor-
the Crown.
Which Crown?